COVID-19 pandemic has many of us thinking about ensuring we have the right legal protections in place for ourselves and our loved ones. And these are often conversations we actually find difficult to have, but it's incredibly important that people know what our wishes are and that we have the comfort of knowing that our wishes will be followed and our loved ones looked after in the way that we want for them. So I wanted to run through 3 really important documents that you should consider, what they mean and the differences between them. And of course, if you have any questions, just call.
What legal documents do you suggest people consider in these times?
So there's 3 really important documents here at PB Lawyers that we definitely recommend that you have in place. The first one is a power of attorney. The second one is an enduring guardianship document. And then the third one would be your will and final testament. So those are the 3 documents that we really recommend that you have in place, especially at times like these. The first document is called a power of attorney, as I mentioned. There's 3 types of power of attorneys. There's a general, there's an enduring, and there's a limited power of attorney that you can have. So a power of attorney initially is just a legal document, and it allows you to nominate somebody. It can be one person, more than one, usually 1, 2, or 3. So these people can act on your behalf. So they can basically manage your legal and financial affairs, and that includes buying and selling real estate. They can also deal with any kind of financials in regard to your shares, any other assets, bank accounts, and also kind of spending money on your behalf. So having to go to the bank and withdrawing money for you or paying bills. So that's what a power of attorney is. So as I mentioned, there's 3 types of power of attorneys. Now, with an enduring power of attorney, that basically covers you. So if you say, for example, you've got a power of attorney in place, which is enduring, that basically means that if later down the line that you do suffer from some sort of mental illness, your power of attorney, so the person that you've appointed, they're still able to continue to make decisions on your behalf. Whereas with a general power of attorney, if you do start suffering from some sort of mental illness, that power of attorney will cease. So it's quite important to have the enduring power of attorney in place rather than just a general. And then with a limited power of attorney, you basically just limit what decisions or what things the attorney can do for you. So say, for example, you can prohibit them from buying or selling any real estate on your behalf. You can limit the amount of monies they can withdraw from banking institutions for you, or the amount of times they can actually attend the bank. So limited is basically what it is. You limit the things that somebody can do for you. But here at power of attorney, we do really recommend having an enduring power of attorney in place. As I said, it just covers you, especially with COVID-19. If anything was to happen to you, and if you were to, struggle with some sort of mental illness down the line, the document's in place, and then your family member or whoever you appoint can then use that document then to then do these things on your behalf. So that's what a power of attorney is. And the person that you actually appoint must be over the age of 18. So it's usually somebody you kind of trust and confide in. People usually have a member of their family, so either your spouse or your children or your grandchildren, or even could be somebody like, for example, your doctor or a lawyer. But basically, somebody that you trust and have confidence in, that will make sure that they keep their financial affairs separate to yours. So the benefit of having a power of attorney is just also the peace of mind, knowing that your assets and financial affairs will be looked after for you by somebody who you trust. And in the event that you, say, for example, unexpectedly fall ill, especially in these current times, or if you experience an unforeseen accident, and you're unable to look after yourself, that you've got this document in place.
How will the current COVID-19 pandemic affect the ability to physically execute the power of attorney?
We can always take instructions through things like a telephone conference or Zoom meetings or FaceTime. But with a power of attorney document, it has to be signed in original form, which does mean that you would have to attend our office using those guidelines, as in we only have one person in the office at a time. We would have to witness your signature in original form. So you would actually have to come out to our office to execute the power of attorney document.
There is a charge to register the power of attorney. Can you explain when a power of attorney be registered as opposed to not registering a power of attorney?
if you were to register a power of attorney, and there is a fee of $143.50, which is payable to the New South Wales Land Registry Services. Now, once your power of attorney is registered, the difference is that your attorney, so whoever you've appointed, they're then able to buy and sell property for you. If your power of attorney is not registered, then they won't be able to buy or sell property. So they can do everything else. They can still do your banking for you. They can still pay your bills on your behalf, but they won't be able to buy or sell any property on your behalf if it's not registered.
What other document do you recommend that people arrange for themselves during these uncertain COVID-19 times?
So another document which is extremely important is called an enduring guardianship document. Now, this is a document which allows you to appoint another person to make personal health and lifestyle decisions about your mental health, physical health and well-being, as well as deciding where you live. The document also allows you to choose which decisions you want your guardian to make, and these are the decisions you can actually put into the document. So here at PB Lawyers, we can provide a draft document incorporating some of these lifestyle decisions you'd want your enduring guardian to have in place. For example, you might want to have make decisions in regards to hospital care or medical treatment, whether you want to refuse it or whether you accept. Also in regards to dental treatment, healthcare, and also decide where you live. And also it can extend to things like life support and palliative care. So say, for example, you'd want to be at home towards the end of your life. That can also be part of the document, or whether you'd like to be in a nursing home or a hospital. All of these things are put into this document. So the appointment of an enduring guardian is important, especially in the event that you lose capacity in regards to mental capacity. And say, for example, you haven't appointed an enduring guardian and you do lose your mental capacity, you cannot then get a solicitor or a lawyer to produce this document for you. You'd have to then go through a division, which is called the Guardian Division of the New South Wales Civil and Administrative Tribunal. And your family members would have to then submit an application to them, and then they will then consider who would be a suitable guardian. And if there is no family member who is a suitable guardian, then they will appoint somebody from their public guardian to make those decisions for you. So as I said, it's important to have this document in place before terribly could happen to you, or something very unexpectedly could happen to you. It's important to have this document in place. So once again, during these times of COVID-19 and signing the document physically, we suggest that such signing is unable to be done remotely, as the document would need to be signed and witnessed in the presence of a solicitor, so they can fully explain the document and sign in the presence of the solicitor and enduring guardian, basically, which is the person accepting their appointment. But in these times, we also make sure that signing will occur following all social distancing protocol and procedures. So here at PB Lawyers, we make sure that we only have the one solicitor and the one client in the office at a time.
Pardeep, what other document do you suggest people should invest in your firm preparing for them during these times?
So the final document that we suggest that you have in place is called the final will and testament. A will is a legal document, and it basically expresses how you'd like your assets to be distributed after your death. So your assets meaning your property, your shares, your bank accounts. And then the will also requires you to appoint an executor. This is basically the person who will then manage your affairs once you pass away. And then they will also distribute your assets according to your will. So usually, for example, if it's a husband and wife situation, and if a spouse passes away, they generally leave their estate to their surviving spouse. And that spouse would also be the executor of the estate. So they're the ones that would deal with everything in regards to closing your bank accounts, and then also distributing any monies. Say, for example, you wanted to leave some money to your grandchildren, or you wanted to leave some money to some certain charities. This is what the executive would do. But say, for example, in certain circumstances where you've got a will in place, but the person you have appointed to receive your estate, which is usually your spouse, if they pass away before you, so if they predecease you, in the will, we also make sure that that's covered. So if you've got children or grandchildren who you'd like for the estate to be given to, so rather than your spouse, because they've now passed away, your estate will then go to your children or your family or your friends or whoever you nominate in your will. But we also make sure that here at PB Lawyers that we advise you on any potential ability for any person to make a claim against your estate. So we also advise you of that whilst we take instructions in regards to your will. So we can initially provide ways of giving advice and obtaining instructions through telephone conferences and FaceTime, and discuss, your will. But in regards to actually signing your will, the actual signing of the will needs to be done physically and signed in the presence of 2 witnesses. The will cannot be signed electronically, as it's got to be in original form, which is the same as the power of attorney and the enduring guardianship document. So we perform signing in our office, and we also, obviously, as I said, we take social distancing into consideration when we do execute the signing of the will.